So Marvin has provided us with a wonderful explanation of the National Academy of Sciences report, and now Chris has taken us through the discovery process and talked about how we can gain information about the expert testimony that we're going to confront through discovery. I want to step back a little bit and talk about the mindset from which we can approach forensic evidence in our cases, and provide some structure so that we can begin to think. Because as Norman says, the onus is on us as the defense bar to think creatively, to think collectively, and to think critically about these different forensic disciplines that are being used against our clients. So first, if there's one overarching theme to this session and to the whole 2 days that we're going to be spending together, it is assume nothing. Assume nothing about the reliability of any particular forensic discipline. Assume nothing about the reliability of any particular expert. And assume nothing about the reliability of how a forensic discipline is being applied in your case. This is one of the reasons why I enjoy working with students and younger attorneys, and why I think clinics do such amazing work, is because those young lawyers, or those soon-to-be lawyers, actually don't know anything, so they ask questions that expose our assumptions, right? And thinking like a criminal defense attorney really is, at bottom, about finding our assumptions and exposing them and getting in that space to raise doubt. So second, start thinking about the forensic issues and the potential forensic issues in your case on day one. Think about what facts might require a defense expert. What facts might trigger the prosecution to use an expert before you get any expert notice or any expert report? Think about what your response might be, what your challenge might be to the prosecution's expert. So, for example, if you're conducting a fact investigation in your case, and you have an investigator, or you yourself are going to talk to an eyewitness. We can talk about it in terms of the case file that we have here. That eyewitness can be asked, did you observe? Did you see the police collecting any evidence? Did you see that part of what happened that night? Because you may now have a neutral witness who saw some contamination, something that you can use to challenge the forensic evidence that the government's going to try and introduce against your client. Think about forensic issues in developing your trial theory. We live and die at trial by our theories. So we need a theory of each particular witness, of each particular item of evidence. For experts, we need an overarching theory about this expert, but then a specific theory as to each conclusion. If the expert has 5 conclusions, do we disagree with all 5? If one of the conclusions is beneficial to us, do we then want to conduct a bias cross-examination or not? So think about the forensic issues as you develop your trial theory. The third is, and this is somewhat a function of how my mind works. I'm a big fan of improvisational jazz music, the avant-garde stuff of the late 60s and early 70s. Coltrane towards the end of his life, Pharoah Sanders, and those folks. And when you study that music, you learn that improvisation really is, creativity in the moment really is, it's not just making it up as you go along. It's based on an enormous amount of preparation. It's deviation from a structure, right? And the structure that I use to think about preparing for trial and to think about forensic evidence and really almost all litigation issues is the trial itself and cross-examination and closing argument. So the third simple point that I would make is remember your audience. As from day one, remember your audience. You're going to have a fact finder, either judge or jury. And everything that you're going to do in that trial is geared towards the experience of that fact finder in that courtroom during that trial, right? So I've actually, I don't know if I'm at an advantage or a disadvantage because of this, but I've never seen any of these TV shows that we've been talking about. Not one of them. But apparently they're very popular, and what it adds up to is that forensic science is interesting to lay people. There's an expectation that they will hear some forensic evidence, see some forensic testimony in court, and you need to be thinking about that. We don't want the most anticipated and interesting part of the trial to be government testimony that goes effectively unchallenged. So think about the perspective of the juror. And because this evidence is likely to persuade, let's be honest, some jurors to the prosecution's way of thinking, in most cases, we want those jurors that are on our side to have something to say during deliberations when this forensic evidence is discussed. So we're providing them with some ammunition. So our mindset is guided by how forensic evidence will be used during the trial. And let's think in terms of the prosecution's expert witness and just talk about some ways in which we can challenge that witness and challenge the forensic testimony that will come in through the witness. The first is challenging the actual expert witness himself. Is this person a scientist at all? Or is this a non-scientist who is effectively presenting scientific testimony based on some methodology that bears no resemblance to the scientific method? Very common. Where are the subjective interpretations in the expert's testimony? Is there exaggerated testimony? Is there misleading? Are there misleading conclusions in the expert's testimony? Some of that language that Marvin was talking about, my God. Consistent with? If you don't challenge consistent with, by the end of the prosecutor's closing argument, it will have morphed into dead on 100% match, this man is guilty. Bias. What you hear referred to as contextual bias. Did the experts see a report that mentioned, a police report that mentioned a client's statement? Did they learn any fact that compromises their neutrality? Is their neutrality questionable just by virtue of who they work for at that time? And I'll give you an example of that in a moment. Does the expert not know enough facts to be useful in your case, to be useful to your jury? What are the limitations of the expert's testimony? For example, you have a homicide case in which the decedent was shot more than once. A critical fact in your case is the sequence of the wounds. Where was the witness hit first? The medical examiner in all likelihood cannot speak to that. Cannot speak to that. And that can be the thrust of your cross-examination. You have taken this expert and basically made them irrelevant to the jury's determination. So the limitations of the expert testimony, sometimes they are critical. Accrediting your defense through the expert. What can this expert say that actually helps you? If the expert is at all neutral, in many cases, they will have, if not conclusions, but points on which they will have to agree with you or sound stupid, which is part of cross-examination, putting the witness in a logical box where they either have to agree with you or be exposed as less than credible. But you can often accredit your own defense through the other side's expert. Personal credibility of the expert witness. And we have a story from the District of Columbia that's an example of this and really shows how vigorous we need to be, not just in getting up to speed on the science, but in getting up to speed and learning who these witnesses are that are going to be testifying against our clients. How many of you have dealt with narcotics expert testimony? Okay, so almost everyone. Effectively, a witness comes in, you have a client. He's arrested with 25 individual Ziplocs, each containing some quantity of crack cocaine. Witness comes in and says, if he has 25, that means he was going to sell it. He wasn't going to smoke it. And the government calls, we say the government in D.C., the state, the prosecution, calls an expert witness to provide that testimony. It's not really science. In D.C., the witnesses are police detectives, literally, current, active police detectives. And one of these witnesses testified for years and years. And it doesn't seem like the most significant testimony in a case, maybe, because it's geared towards that one element. But while this witness was testifying, while the government was relying for years on this particular expert, the maximum penalty for possession with intent to distribute cocaine was 30 years. The maximum penalty for misdemeanor possession, simple possession, possession with intent to use, was 180 days. So this man's testimony is geared towards an element that results in a 29.5-year swing in your client's exposure. After he'd been testifying for I don't know how many years, someone finally took his CV, line by line, and attempted to verify it. And what they found was that he had misrepresented his education. He said he had a chemistry degree. He actually didn't have it. For years, he testified with that CV. And it happened because no one ever checked it. What are the organizations that they belong to, the so-called certifications that they have? Chris referenced this. Some of these groups, you pay a $25 annual fee, and now you're an expert in some science that you've never studied. They will, during voir dire, list voluntarily some of these organizations that mean nothing about their reliability or the quality of the forensic examinations conducted in your case. Attacking the science itself. Is the science, and we now know, based on the NAS report, that almost all of this science, to the extent that science is a generous characterization in some of these disciplines, but that none of it is beyond question. So in thinking about attacking the science, look for contrary scientific views or dissenting scientific views, not necessarily with the goal of presenting them through your own expert in court, but just because it gives you ammunition to think about challenging the prosecution's testimony. It gives you something to think about, because we're not always going to be able to intuitively figure out how to challenge science that's being presented against our clients. So then, the science as it's being applied to your case. You will have cases in which the prosecution and the expert are expanding the boundaries of their typical conclusions. Now, Chris has explained the discovery process. I just want to talk to you about a few ways with that mindset that we've talked about, and hopefully this tees up our brainstorming session this afternoon. We'll talk to you about a few ways to gather information outside of the discovery process. I'm a proponent of interviewing prosecution experts. It's something that many do, but many defense lawyers don't, and when you talk to many prosecution experts, they've never or almost never been contacted by a defense attorney. I recommend conducting some of your own research before you talk to that expert so that you can ask intelligent questions and at least be conversant in the science and also in the report that they've issued in your case. What you find when you interview and examine these experts is very often, if you ask them, or you try and get at, what are you really relying on? What are you relying on as the basis for this conclusion? What is it in your experience, your training in the science that got you from A to B? You will find some very shaky answers, and sometimes you will literally hear my experience. I'm relying on my experience. If you get that answer or something like that, you're obviously going to incorporate that into your cross-examination of that witness. Many of these experts get very comfortable testifying over time because their conclusions aren't often challenged vigorously. Is an expert straying beyond their area of expertise? Are some experts straying into providing medical testimony? What exactly did they do in your case, and what exactly didn't they do, and why? What tests were conducted? What tests could have been conducted that weren't? Were they instructed by anyone or guided by anyone to conduct or not to conduct certain tests? Has any court, and this goes to what Marvin was talking about, has any court ever declined to qualify this expert in any area? Gathering transcripts. Prior transcripts of the same expert's testimony can be of tremendous value. And just simply asking the expert about their report. What does cannot be excluded as a source mean? What does that mean? You're going to hear about some great resources. The NLADA's database of forensic resources, NACTL Forensic Library, scientific working groups, CRC Press. There's all sorts of resources out there that you can consult, and Gene has particular experience applying some of what we've been talking about in the arson context.